So now, let's explore the fascinating overlaps between data protection and intellectual property. And this session will be moderated by Kevin Fournier, Director at Kevin J. Fournier, Intellectual Property Legal Services Limited, UAE. And the panel members are Valentina, and she's a senior counsel at... I'm so sorry, I was not able to... Thank you so much. And she's from Italy. Please welcome them on stage. Okay, I will call him. Kevin. Call Kevin. I'm so sorry, I was not able to pronounce. No, she's not coming. She's not well. You can take this.
Yes, I would like to.
Okay. Yeah, sure. Welcome, Kevin.
No, okay. It's a good thing I had a coffee before then.
All right.
Get my notes, hold on. I'd like to introduce the panel first. I'm the moderator, and I may end up providing some content now that there's only two of us,
Yes.
but I will, we'll see how it goes. So I'm Kevin Fournier. I am an intellectual property lawyer based in the UK. I do practice U.S. law as well because I'm from the U.S. originally, and I seem to mainly practice these days U.S. patent law before the USPTO. I also work before the European Patent Office. I'm qualified there as well. And the UK Patent Office, I work there. So I'm mainly a patent attorney. I also handle a few data protection issues in contracts. If a client is small and they need me to put together a overall terms of use for a website or something like that. So I've got some experience with the data protection laws, but nothing like my co-panelist. So I shall pass over to Valentina to introduce herself.
Yes, hi. Hi. No, hi. Yes. Hi, my name is Valentina Giarrusso. I am a qualified lawyer from Italy and also a registered foreign lawyer in the UK. I work in Italy. I'm based in Milan, and I work for a law firm called Giambrone. Giambrone exists since 20 years. I joined in 2010, so it's 15 years now that I cooperate with them. And it was born with it was just an Anglo-Italian private client firm. But 15 years ago, I had the chance to meet with the managing partner, and we decided to bring my corporate experience since I used to work in Milan for a big US law firm in the corporate sector. So we decided to bring my experience to some way transform this small private client firm in a global law firm, which is now, they have like 18 offices all over the world, and we are more than 200 professionals. I decided to deal with the corporate side, but mostly revolving around compliance. In 2020, during lockdown, I decided to, since I was very bored staying home, I decided to start studying data protection, which is something that really took my heart. It is something I'm very passionate about, so I decided to study it myself. I followed a number of courses also at with the London School of Economics, and I decided to write articles and make contributions because this is something that really, really interests me. I'm now coordinating a group of lawyers that do also IP, but I'm much more into data protection, so I feel like an imposter today, a bit.
No, half the topic is
Yes, so we are trying today with Kevin to talk about the overlaps and possible example of intersections of these two areas, and to discuss this a bit.
Yes. Is this microphone? Yes, it is. Okay. Yes, so the overlap between these two areas. I think there's a lot of analogies between the two areas. Personal data is data that is valuable, and like intellectual property is valuable, and it's also information or data. It can be. I would think like a trade secret would be a very close analogy because it's if it's secret, you know, of course, the personal information. But if it's your name and address and if that's public, then it can't be a trade secret. But I mean, if it's something secret about yourself, that could be, you know, similar to a trade secret. I think it's important for, you know, we're IP lawyers, most of us, you know, here it's an IP conference. I think it's very important for IP attorneys to understand some of the basics of data protection. I also have done a little bit of research during the pandemic to try to understand it because it seemed like an interesting area and it seemed like it was a close cousin of intellectual property in some way. And I had clients that were asking me to prepare like terms of use for websites, and then as part of that there's a privacy policy that we often see on websites, and also data protection agreements that are required. So yeah, I think it's really important for IP attorneys like all of us and myself to understand, and we're very honored to have you here to explain some of this. So yeah, I mean, we're going to talk about the analogies between IP and data protection because you can kind of draw some broad analogies here. So Valentina's got some material to present that will help us with that. Do we have, the slides are working? Okay, okay. Are they loaded up? Yeah? Okay. No, yeah.
Is there anybody who can change the slides? Yes.
You can use this.
Oh, I do. All right. Well, this is difficult then. Okay. So, good morning, ladies and gentlemen. It is an honor to be here today at this IIPLA conference. And, well, I would like to start with a striking example of why this overlapping and this argument is very important and critical today. In 2023, companies around Europe faced GDPR, General Data Protection Regulation, fines totaling 2.9 billion. And a significant portion of these penalties affected IP-heavy sectors like technology, media, and pharmaceuticals industries that are the forefront of innovation, but also at the epicenter of data protection challenges. These figures underscore the pressing need for a balanced approach that safeguards personal data while protecting intellectual property. Let me... How? Yes, thank you. Thank you. So, my speech today will focus about this dual challenge, which is fostering innovation while respecting fundamental rights. And my objective today is to explore the legal and practical implication of this interplay, with a special emphasis on Italian and European Union law. Let us start by setting the stage. So what is the stage? The stage is why, how, when, and where these two domains overlap. Well, first of all, I would like to start by talking a bit about the very heart of the data protection in Europe, which is the General Data Protection Directive, the General Data Protection Regulation, which is the GDPR. And the core principles of this regulation are outlined in Article 5. Article 5, as most of you already know, talk about lawfulness, fairness, and transparency. So, data processing must be lawful and transparent, with individuals informed about their data is used. Then there is the purpose limitation principle. Personal data must be collected for specific, explicit, and legitimate purposes, and not further processed in ways which are incompatible with those purposes. Then we have data minimization and storage limitation principle. Only the data necessary for the specified purpose should be processed and stored, and no longer than needed. So, this is the core of the regulation of data protection in Europe, that of course has been implemented by member states and also by Italy in a very effective way. Now, intellectual property exists to protect the creation of the human mind. So, fostering innovation and creativity by granting rights to creators and innovators. It encompasses a wide array of protections, including copyrights for artistic and literary works, patents for inventions, trademarks for brand identifiers. And the goal is to ensure that creators can reap the benefits of their creations and encouraging ongoing contribution to science, culture, and industry. Data protection, by contrast, or not by contrast, in agreement with that, is about safeguarding individual personal data. It ensures that privacy, which is a fundamental right as set forth in the Charter of Fundamental Rights of the European Union, is respected. So, with the proliferation of digital technologies, personal data is now an invaluable resource which necessitates a strong frameworks to regulate its use. But how these two domains overlap? I would give you a couple of examples. I'm not going too much in depth because my time is limited, but I would say database. Database is a compelling example of how these two domains overlap. A database may qualify for copyright protection under Database Directive. This directive recognizes copyright for database that exhibit originality in their selection of arrangements and grants sui generis rights for significant investments in their creations. However, if a database contains personal data, GDPR strict rules on lawful processing under Article 6 and 9 must also be observed. So this interplay demands a dual compliance approach, ensuring that both database intellectual property is protected and individual data rights are respected. Now, the Database Directive, as I told you, is the main piece of law which regulates the database. And Italian law has also implemented this, making a distinction between original databases, which are covered by copyright, and non-original databases in Italy, which are covered by sui generis rights. So incorporating main rules of the database directives. Another compelling example could be done by trade secrets, as Kevin was saying before. Trade Secrets Directive protects valuable, confidential business information. Trade Secrets Directive protects against the unlawful acquisition, use, and disclosure of confidential business information, such as, for example, research data or customer lists. Now, GDPR introduces potential tensions on this, which is Article 15 of GDPR, the access rights. Individuals have the right to access their personal data, potentially challenging the confidentiality inherent to the trade secrets. For example, if personal data is embedded within a trade secrets, let's say, for example, customer records, companies must balance these access rights with the need to protect their trade secrets. Now, the directive, the Trade Secrets Directive, has been implemented in Italy in 2018 by a legislative decree that substantially replaced the old Italian Industrial Property Code, the CPI. And what we can say about this is that a lot of work has been done to mitigate and to find the balance also by the Italian and European courts. Well, Italian courts have been instrumental in interpreting and shaping the relationship between copyright and data protection, addressing conflicts and overlaps in significant rulings. The key areas of jurisprudence covered by Italian courts are the dualism between databases with personal data. So courts have consistently held that databases containing personal data are subject to both copyright or sui generis rights and GDPR. The mere fact that the database is protected under IIPLA does not exempt it from GDPR's obligation. I would give you an example. A ruling emphasized that companies using personal data in database protected by sui generis rights must respect GDPR principles of purpose limitation and data minimization that I was talking about before. Another example, another area covered by Italian courts is the dualism, the dichotomy between fair use versus data protection. Italian courts have balanced copyright exceptions, such as for academic or research purposes, with GDPR requirements. When using copyrighted works for research that involves personal data, courts require strict adherence to GDPR principles, such as anonymization of data subjects. The last point that has been covered by constant jurisprudence in the last year is transparency versus data access rights. Courts have reinforced GDPR's access rights in scenarios when personal data is part of copyrighted works or databases. For example, individuals may request access to their personal data within a copyrighted data set, potentially challenging trade secret or copyright protections. There is a case involving a copyrighted database of biometric data used in a research project, which raised the question of individual access rights versus the database owner's IP protections. The court ruled that, this is very important, the court ruled that GDPR access rights takes precedence, but allowed the database owner to anonymize sensitive information not necessary for access compliance. Now I would like to go to have a look to European Court, the European Court of Justice, who in a couple of cases that I decided to recall, established some very important principles about it. European Court of Justice, in case Rigas Satixme, clarified the definition of personal data under GDPR. The case arose from a dispute where an individual requested access to personal data held by the company, which is a public transport company. The data in question was captured by surveillance camera installed on buses. The ECJ was tasked with determining whether images and related metadata fell within the scope of personal data under GDPR. The court held that personal data includes any information relating to an identified or identifiable natural person, directly or indirectly. And the ECJ, European Court of Justice, emphasized that even fragments of information, when combined, could enable identification. This interpretation broadened the understanding of what constitutes personal data, ensuring that databases containing such information, even if initially created for security purpose, are still subject to GDPR. The second case I would like to recall is the Schrems second, which, while primarily concerns international data transfers, in reality underscores GDPR's strong extraterritorial reach and its very strong enforcement mechanism. The case is centered around the validity of the EU-US Privacy Shield framework, which allowed at the beginning for transatlantic data transfers under specific conditions. The European Court of Justice invalidated the Privacy Shield, finding that it was not protecting EU citizens' data from US surveillance programs, as required by Articles 4450 from 44 to 50 of the GDPR, governing data transfer. The ECJ emphasized that any mechanism enabling data transfers outside the EU must ensure a level of protection which must be essentially equivalent to that guaranteed within the Union. This decision imposed a strict compliance requirement on business engaged in cross-border data flows, including the use of the standard contractual clauses. This ruling has significant implications for IP-intensive industries, particularly those reliant on global databases, cloud services, or collaborative innovation platforms. It highlights the necessity for strong data governance strategies to align with GDPR's adequacy standards and balancing the operational needs of IP management. Furthermore, the case reinforced the importance of conducting regular assessments of international data transfer frameworks, which is part of my job, by the way, to mitigate legal and reputational risks associated with non-compliance. The invalidation of the Privacy Shield impacts IP-reliant industries engaging in massive cross-border data exchanges, stressing compliance with GDPRs. As we have understood what the legal and case law framework is, that there is the need to find a balance between these two legal domains, and that the overlapping often leads to conflicts. These conflicts required a solution. Courts and regulators invoke key legal principles to achieve this balance. And these principles are proportionality. The principle of proportionality is a cornerstone of European Union and Italian law and jurisprudence. It ensures that measures taken to protect one right do not infringe upon another. I would like to provide you with the example of proportionality. Trade secrets versus access rights, GDPR access rights. Trade secrets are protected under Trade Secrets Directive and implementation under Italian law. However, individual access rights under Article 15 GDPR may require disclosure of personal data embedded in trade secrets. Courts assess whether disclosing specific personal data satisfies the individual GDPR rights without unnecessarily compromising the confidentiality of the trade secrets. For example, if a trade secret involves customer purchase data, the court might require selective disclosure of only the requesting individual's data while preserving the confidentiality of the other records. Another example is copyrighted database and data subject rights, which is another example of, let's say, overlapping which needs to be addressed. Database protected under the Database Directive may contain personal data, as we have seen. The principle of proportionality requires that data controllers balance the database owner's IP right with the GDPR rights of data subjects. Italian courts have ruled that personal data within a copyrighted database must be disclosed to the individual upon request, provided it does, this is very important, provided it does not undermine the overall commercial viability of the database. So another example of try to find a balance and to proportionality. The last one is artificial intelligence and proportionality. When artificial intelligence models use data sets containing personal data, proportionality ensures that IP protection for the data set do not justify excessive personal data processing. For instance, anonymizing data for training purposes is often required to strike the balance. Another principle that must be taken into account to try to find a balance is the principle of legitimate interest. Under GDPR, Article 47, the processing of personal data based on legitimate interest is allowed. Provide the legitimate interest of the data controllers, provided these interests do not override the rights and freedom of the individual. For example, the IP protection is a legitimate interest. Business and companies often invoke legitimate interest to process personal data for purposes such as protecting IP. Let's make the example of an investigation of unauthorized use of copyrighted material or trademarks. So, monitoring compliance with IP licenses maybe sometimes requires an investigation which, creates tensions under the perspective of data protection. So, courts and regulators require a balancing test to determine whether the legitimate interest is outweighed by the impact of the individual privacy rights. For example, a software company tracking IP addresses to identify piracy must ensure the tracking does not involve excessive or intrusive data collection. Companies, another example is the practical application in trade secrets. Companies may rely on legitimate interest to process personal data that forms part of trade secrets, the customer list. However, such processing must comply with GDPR principles like data minimization and purpose limitation. A business protecting a trade secret database of client preferences can process data to prevent unauthorized access, but must limit processing to what is strictly necessary. The last principle that has inspired legal framework and jurisprudence is fair use and exceptions. IP laws incorporate exceptions and limitations to balance the exclusive rights of IP holders with public interest or other competing rights, parody, quotation, criticism, research and teaching exceptions, text and data mining, public interest expectations. Certain public interest activities, such as reporting on public health, for example, health crisis, or conducting public policy research may justify a limited use of copyrighted works and personal data. However, both IP and GDPR obligation must be carefully balanced. Let's make an example of an NGO using copyrighted photographs containing personal data to highlight a humanitarian crisis, which must ensure that the data subject privacy is respected, such as through anonymization or obtaining consent. Now, the interplay between GDPR and IP presents both challenges and opportunities, with profound implication for legal and operational strategies. Conflicts arise in areas such as GDPR's transparency obligations require clear communication with data subjects under Article 12.14 and IP confidentiality needs, particularly concerning trade secrets protected under the relevant directive. Cross-border data flows highlight the complexity of maintaining GDPR's compliance while enabling seamless global collaboration. Balancing compliance with innovative demands, proactive strategy that incorporate privacy by design principles, as outlined in GDPR Article 25. Innovative legal doctrine, such as the proportionality test, play an important role. For instance, courts often weigh the legitimate interest of IP holders against data subject privacy rights to determine the lawful boundaries of processing. Blockchain technology, by decentralizing data storage and enhancing traceability, offers a promising solution to try to reconcile GDPR and IP demands. Furthermore, there is this Emerging Data Governance Act, which introduces frameworks to harmonize data sharing practices, paving the way for a more integrated legal landscape. Well, what I would like to say is that I would like to conclude by saying that intersection of intellectual property and data protection is not merely an academic theoretical discussion, as it may appears to be today, but it is a pressing real-world challenge that requires careful and deliberate navigation. As technological advancement continue to reshape the landscape of innovation and privacy, the interplay between these two domains becomes increasingly significant. Well, we see that intellectual property seeks to incentivize and protect creativity and innovation. And data protection focuses on safeguarding individuals' fundamental rights. At their intersections, there are two questions that we have to address. How do we protect IP assets that involve personal data without infringing on privacy rights? How do we enable innovation, particularly in the area like artificial intelligence and big data, while ensuring compliance with a robust data protection standards? The answer lies in the word balance. So, balance is achieving harmony between these objectives through intelligent legal interpretations and practical technology-driven solutions like blockchain. Achieving balance between IP and data protection is not only about legal compliance, but it is about creating a sustainable ecosystem where creators and innovators are incentivized to contribute to progress. Companies can thrive while respecting individual rights, and individuals feel confident that their privacy is protected, even in the face of rapid technological advancement. Thank you for your attention. I would like to go back to my very patient
No, that's fine.
panelist colleague, and I'm going to sit back there for your question.
Okay. Thank you very much, Valentina. You've really dove in deep with your experience in data protection, and you've not only told us about data protection, but you've also compared it in detail to the IP rights that are most relevant, which was very, very helpful. coming from the IP attorney's perspective, I'm going to draw some analogies, some really broad brush analogies between IP laws and data protection from the point of view of the very basics of intellectual property, and then seeing how data protection could fit in there in a bit higher detail. So the first area of analogy is subject matter eligibility. So for patents, we have statutes and laws, sometimes in cases, which say what can be patented, what can be copyrighted, what's the subject matter of a trademark. Like in patents, it would be the, in the US, there's a Section 101 test known as the Alice test. What patentable subject matter, exists. For copyrights, there's the idea expression dichotomy. You can copyright an expression, but you can't copyright the idea. So that's again subject matter eligibility. Now we turn to data privacy. We have a broad definition of in the GDPR of personal data. It's any information relating to a natural person who is identifiable. So that's very similar, I think, to the patentable subject matter under the Alice test in the US, and the copyrighted subject matter under the idea expression dichotomy, and trademarks like a name or a brand that represents the goods and services that a company is selling. So those are kind of the eligibility analogies that I saw. You can really see that data protection can be considered very loosely as a type of intellectual property, and it might be so going ahead. People might consider data protection as intellectual property in the years to come as data becomes more and more valuable. So the second area is using the information. So for patents, you're not allowed to make, use, or sell a product covered by the claims of a patent, or practice a claimed method if somebody has a patent on something. For copyrights, it's really about copying the work itself, as we know, distributing the work. Now we turn to personal data. We try to make I've tried to make an analogy here. So for personal data, it's processing the data. What do you do with the data? You can process it. If you, whether or not you have the permission to do so is the same as whether or not you have the permission to make a product under somebody's patent. So I kind of see that as an analogy. So doing something with the data is processing it, analyzing it, using it to draw conclusions, or making predictions using an artificial intelligence engine or model, for example. You're making use of that data, and we've already heard from Valentina about the interface between artificial intelligence models with data that could be included in that model. So you really, like with patents, where you have a license to use that material, you could have a license to use the personal data within an artificial intelligence model, for example. So the third area is the originator of the protected information. So with patents, it would be the inventor. Who originated this this information that's being, or this concept that's being protected? The inventor, if it's a patent. Copyright, it would be the author, of course. For data protection, we have something known as a subject. So that's, I see that as analogous with the inventor of a patent, or the author of a copyright. So the person to whom the personal data relates to, it could be somebody's name, birthday, birthplace, your photo, or a video that you've made of yourself. This is similar, I think, to an inventor inventing a patentable invention. The fourth area is a third party who is not that party that originated this information would need a license or permission to do something that's protected. Like for patents and copyrights, you would be an infringer if you didn't have the right to use the intellectual property and you used it anyway. For data protection, this third party is called a processor. So if the processor is doing something with someone else's personal data, that's kind of like a license. A third party who did not come up with the intellectual property, but they have permission to use it as a third party licensee. The processor is the equivalent there. So I think I'm trying to make analogies here between IP and data protection. So the last one I saw was, how is that IP right or data protection right managed? Keeping it, managing it, growing it, the garden kind of analogy where you have seeds growing in a garden that people often use. How do you nurture or culture that kind of right? So for patents, you have somebody called a patent portfolio manager oftentimes in a company that looks at all of the patents that a company has and decides, are we going to keep this patent alive in these countries, or are we going to let it drop in certain countries? Do we need more patents in this particular area? Are we running out of, do we not have enough patents in one area? Like a balancing or a managing of a patent portfolio for patents. So for data protection, this would be the data controller, the manager, or the equivalent of the patent portfolio manager. Could be like a data controller. The data controller decides how much security the data processor has to put in place to protect the information. So this is similar to protecting trade secret information using an NDA, non-disclosure agreement. So the person who is controlling the use, the validity and the existence of that information could be considered analogous to a patent portfolio manager or a trademark portfolio manager even, data controller is the counterpart there. So I think there are analogies here that could reasonably justify data protection as being a type of intellectual property. So if we look at how data can be protected, personal data can be protected under the IP laws currently, there could be trade secret, like we talked about earlier, that I'm going to summarize here, that if the data is kept secret, it could be shared under NDA, like a video or an image of somebody. It could be kept secret, and it could be a trade secret. Copyright, if you have it written down in a document of some kind or stored in a database, as we've heard, then it could be protected under copyright or database rights. And a trademark, if you have your name or image, like a brand, I know there's laws now in the US, they have laws that protect people's image, like famous people's image, and that kind of, could be like a data protection analogy as well. Possibly a trademark such as the Kentucky Fried Chicken gentleman with the white suit and the white hair and beard could be, that's the image of the person, that's personal data. There's an overlap there. So yeah, I think those are the areas of analogy that I've seen with the IP laws and how IP can possibly protect personal data as well. So yeah, I mean, we've both given our sides. I've given the IP side. Valentina's given the data protection side of the issue. So we really, both of us would like to know if anybody has any questions or any contributions they'd like to make to the discussion. It'd be really nice. Anybody have anything? Question, comment?
Any questions from audience? No questions.
Okay. Well, thank you, everybody, and thank you, Valentina, for the lovely presentation.
Thank you, everybody, for your attention.
Yeah.
Thank you so much, Kevin and Valentina. And now I would like to request Kevin to honor Valentina.
Okay. There you are. Thank you very much.
And this is for you, Kevin.
Oh.
And I would like to request Valentina to please honor Kevin.
Of course. Okay, so Kevin, this is for you. Thank you.
You're welcome.
Thank you so much, both of you.
You're welcome.
So quickly, I would like to invite Azam Ghani to please